We will go on the record in the matter 25 CF 125, State of Wisconsin versus Charles Krakowski. The state appears through District Attorney Kevin Schmidt in person. Mr. Krakowski appears in person with counsel Joel Feliski. Mr. Krakowski is in custody. We're set for a plea and sentencing. The parties have reached an agreement. Mr. Feliski, please recite the agreement on the record.
Thank you, Your Honor. The parties have agreed here for Mr. Krakowski to plead to count 1 in 25 CF 125 without the repeater. The remaining counts will be dismissed and read in. The parties are stipulating as to the restitution that's been requested. However, the parties will be making an argued sentence with the state capped at a recommendation of 3 years initial confinement and eligibility for ERP after 1 year. I have a completed plea questionnaire and waiver of rights form with me. May I approach?
You may. Victims' rights compliance?
Yes, Your Honor.
Thank you. Basis for the agreement reached, Mr. Schmidt.
I think it involves enough incarceration appropriate with what the offense is and his criminal history.
And he's currently sitting a prison sentence or ES? No.
Your Honor, he was, I apologize. He was revoked, so he is scheduled, once his cases are resolved, to be remanded back into the prison system.
The status of the DOC case is he's doing something called a reconfinement hearing, meaning a person can say, yes, you have a basis to revoke my ES, but I disagree with what DOC says is the amount of time I should get. So he's being revoked. It's just we don't know how long.
Do we have what DOC's recommendation is?
Yes, it's 2 years, 2 months, 2 days.
That sounds right.
All right, thank you. Okay, so Mr. Krakowski is having a moment with his attorney.
Sorry.
No, you can take your time.
I'll agree that 2 years, 2 months, 2 days. Without changing it, that makes it.
Mr. Schmidt, case number he's being revoked on.
It is
I have it open in a window. Poke 08 CF 138.
Court is taking judicial notice of Polk County case number 08 CF 138, State of Wisconsin versus Charles Krakowski. There, he pled guilty to 1 count of burglary, arming himself with a dangerous weapon, a Class E felony, as a party to a crime. And he pled guilty on August 24th, 2010. Had a sentence. He was on extended supervision. He is now being revoked off of that extended supervision. Okay, anything further you'd like me to know, Mr. Feliski, before we begin?
Your Honor, if I could have 1 moment to speak to the state.
You may.
Thank you.
All right. Anything that I should be aware of, Mr. Feliski?
Not at this time, Your Honor.
Okay. Doesn't affect the agreement or anything?
No, Your Honor.
All right. I have in front of me a plea question or waiver of rights form. Mr. Krakowski, do you recognize the document?
Yes, I do, ma'am.
Did your attorney go over this document with you thoroughly?
Yes, we did.
Essentially, word for word.
Yes.
Did you understand everything completely?
Yes, ma'am.
And if you did not understand something, did you ask him to explain it?
I would have.
But you
but-
understood
But I
everything.
understood everything, yes.
And that's your signature on the second page?
Yes, ma'am.
You are pleading guilty to one count of burglary of a building or a dwelling. You're 58 years old. You have 12 plus years of schooling, which would include some college. You can read, write, you understand the English language, all correct.
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes,
Did your attorney thoroughly go over with you the maximum possible penalty you face?
yes,
You are not receiving treatment for any mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours, correct?
no mold altering, just for heart medicine is all.
And that's nothing that interferes here?
Nope.
Nope, you're all good.
Yep,
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on the first part of this plea questionnaire. Did your attorney thoroughly go over those rights with you?
yes, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, ma'am.
Do you understand you will no longer have the right to a trial? You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you.
Yes, ma'am.
You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Absolutely.
Do you understand you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
I understand.
You will no longer be able to vote in any election until your civil rights are restored.
Correct.
Now, do you understand that here the state would have to prove as to count one, burglary of a building or a dwelling, and this is without the repeater, correct?
Correct.
Form a motion to remove repeater.
So made.
Granted. So as to count one, without the repeater, the state would have to prove on or around August 26, 2025, in Burnett County, Wisconsin, you intentionally entered a building and a dwelling owned by MT without the consent of that person in lawful possession of that place with intent to steal items of value. Do you understand what the state would have to prove?
Yes,
Do you understand the maximum possible penalty of this class F felony could be a fine of up to $25,000 or imprisonment of up to 12 and a half years or both? Do you understand that?
yes,
And do you understand that there is an agreement that's been reached between the parties and that you've accepted, and it was recited on the record? Do you understand as it was recited?
yes, I do, ma'am.
Do you understand that I'm not bound to follow any recommendation?
I understand that.
That means I could sentence you based upon the facts of this case, your history, and the totality of all of the circumstances to a different sentence. Do you understand that?
Yes, I do.
And it could be the maximum possible penalty. Do you understand that?
Yep.
Do you still wish to proceed and enter a guilty plea?
Yes, I do, ma'am.
Now, did you go over the criminal complaint with your attorney?
Yes,
In particular, there is that section called the probable cause section where it basically says what happened and why you were charged with the crimes. Do you remember that?
yep,
For the most part, are those facts accurate?
yes,
Are you admitting here today that you in fact did have a burglary of a building or a dwelling with MT's property?
yes,
Are you admitting here today that you did enter the building and dwelling with the intent to steal items of value?
yes,
Are you pleading guilty to this charge because you are guilty of this offense?
yes,
Mr. Felisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
none other than the plea agreement.
Other than the plea agreement, no one's
No.
promised you anything?
Nope,
No one's threatened anything with you and said, if you don't plead, something's gonna happen, or some other type of threat?
nope,
And no one's promised you $1 million or anything like that?
no, ma'am.
Okay, so no one's made any threats or any promises, and so you're doing so freely, intelligently, And so that means you're telling me you understand everything that's going on here today?
Yes, ma'am.
And you're doing so voluntarily?
Yes, ma'am.
Has your attorney represented you competently?
Yes, sir.
Has he, what?
Yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
I believe so. Yep.
And are you satisfied with his services?
Yes,
Did he go over all of the discovery and the evidence with you in this case?
yes, ma'am.
Has
Word
he
for word.
discussed, what?
Word for word.
Excellent. And has he discussed any potential defenses you could have or a lack of defenses you could have?
We discussed it, but we decided to go against it.
All right, but he went
Yes,
all over all that.
we
with
went
you.
through it all.
And in going over all of that with him, you told him your side of the story and your facts
Yep,
and any alibis or any other people that may be involved, all the information that you are aware of.
yes,
And then in your discussion with him, you made the decision to accept the agreement from the state.
yes, ma'am.
And so you're pleading guilty because you're guilty of this charge?
Yes, ma'am.
Okay. Do you have any questions for the court or for your attorney before I proceed?
Nope, I have a statement I would like to read eventually.
You will get to do that. So Mr. Feliski, do you believe that your client is entering a plea freely, intelligently, and voluntarily?
I believe he is.
He has a full understanding of the rights he's giving up, as well as what the state would have to prove his guilt beyond a reasonable doubt.
I believe so.
And he understands any potential defenses or lack of defenses he could have in this case.
We have discussed them and I believe he understands them.
All right. And any reason why the court should not accept a plea of guilt from him here today?
I see no reason as to why.
Okay, thank you. One last time, do you have any questions for the court or for your attorney before I proceed, Mr. Krakowski?
No, ma'am.
Okay, then as to count one, burglary of a building or dwelling, a class F felony without a repeater, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. The remaining counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Mr. Krakowski, are you telling the court here today that you do stipulate to the amount of restitution in $2,930?
Yes,
All right. Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. The state's going to be recommending that the court sentence Mr. Krakowski to Wisconsin State Prison System for a period of time of 3 years initial confinement, 3 years extended supervision. State's going to be asking that he be found eligible for participating in the ERP, the substance abuse program, after serving at least 1 year. And the state's going to be asking for it to be run consecutive to any other sentence. So this is a case where Mr. Krakowski was kind of just caught red-handed. We happened to have a GPS on his vehicle. As we were monitoring it, we saw his vehicle go to a spot where we didn't think he had any business to be. We contacted the owner of that property. Do you know Charles Krakowski? No, we don't. So we went up there, saw it was obviously stolen. Saw it was obviously burglarized. And then we went to where Mr. Krakowski's vehicle was, found the stolen property. The victim confirmed it. We checked some cameras we maintained in between the burglary location and where the property was found. Saw his vehicle with the property in the back in it. It was a truck, so it was just visible. So the investigators even took like the pieces cut off of the vehicles there and like connected them and saw like the cut marks match. They really went to an extreme degree to figure that out. When this occurred, Mr. Krakowski was on extended supervision for that 2008 case, which was a burglary itself. He was also on bond in a Barron County possession methamphetamine case, which is why the state's saying he should be eligible for ERP. He does have a substance abuse issue. The reason why the state's saying this should be a prison case and the court shouldn't start with a probationary sentence is, well, one, it wouldn't make sense for a person to get probation when they commit a burglary while on extended supervision for a burglary. Two, Mr. Krakowski has a history that's related to theft and burglaries. Of his convictions, he's got one prior conviction for that 2008 burglary, armed self in a dwelling. He has another conviction for burglary. He's had 2 burglaries read into other dispositions, and he's had 2 burglarious tools read into other dispositions. Otherwise, his others were the felony bail jumps. He does have at least 1 prior possession methamphetamine conviction as well. He had an amphetamine in Burnett in 2006. He had a methamphetamine in Polk in 2008. He had a meth in 2016 in Burnett County. So he does have the long history of substance abuse as well, in particular in relation to methamphetamine. That being said, Mr. Krakowski also is capable of working and has worked and paid things in the past. So he's not somebody who accumulates large amounts of restitution and never pays it. So that's another reason why we would want him to, not do an incapacitation sentence where we max him out. We would want him to get out and work and pay back this restitution towards the victims. So that's why the state doesn't think it's appropriate to go higher than what this recommendation is. The state does believe this has to be a consecutive sentence. I don't see how it would not depreciate the seriousness of this offense or the previous conviction to run a 2025 burglary concurrent to a 2008 burglary. That's just so long ago, and it was in a different county with different people. I was graduating high school that year. It's so far in the past. So that's why the state really thinks this needs to be consecutive. If what he was on supervision for was more recent, maybe the analysis would change, but that's 18 years ago. So that's also why the state's making this recommendation where if the court follows it and he becomes eligible for ERP after 1 year, the way it would structure is whatever he'd get in the reconfinement time on the 2008 case he'd serve, then he'd serve the year on this, and then he could do ERP. Well, he could start the ERP sooner than the year. He could get out within a year of this sentence. So in total, if they did just do the reconfinement time, he'd be in prison less than 3 years because obviously he's accumulating a lot of credit right now. So he would have a short prison sentence. Then he'd get out on ERP, which would deal with the methamphetamine, which is most likely related to the thefts. And then he'd be on the supervision again. I don't know how much supervision he'd still have. He's gone back and forth with prison on that extremely long. 2008 went a long time. The way ES works is when you go back, it restarts again, which is how, he got a 10-year sentence that he's still serving 18 years later. It's just an oddity with how ES works in Wisconsin. So no matter what, I think he's going to be on ES for a long time yet, even after this sentence because of the revocation, which should help protect the community. It did help protect the community, this case. That's how we caught him right away on this, the lower standards for people on ES. So that's why the state's making this recommendation. It's consistent with the McCleary-Gallion factors. It's a sentence that doesn't depreciate the seriousness of the offense or the past 2008 offense. It gives Mr. Krakowski a real benefit to doing substance abuse and stop doing this. We could talk compass, we could talk risk assessments, but the 2 main factors that assess risk are prior history, which is bad for him because it's related to, thievery and burglary. But on the other hand, he's right at the age where his criminal history should be going down. Study shows you hit certain old ages that crime drops off as people just physically aren't capable of it, or they mature, or there's something with the brains. He's right on the edge of that. This offense happened while he's on the edge of it, so I still don't think he's there. But taking all things in totality, this is what the state would recommend. Thank you.
Thank you. Mr. Felisky?
Thank you, Your Honor. I'll first address the issue of credit. Mr. Krakowski was brought in on arrest on these charges on August 26th of 2025. He's been in custody since that period up until today. By my math, he has, as of today's date, 182 days of credit. Your Honor, we're asking for 2 years of initial confinement on this case, 2 years of extended supervision, eligibility for ERP after 1 year, along with eligibility for substance use program to run concurrent to Mr. Krakowski's revocation. A few things I'd like to address first, Your Honor. Mr. Krakowski very deeply regrets his actions here. And not to opine too much on it, but I believe that this was a poor decision or a series of poor decisions that were drawn out of both panic, impulse, and then past trauma. Reviewing the sentencing memorandum submitted to the court, Your Honor, I was struck by what my CSS had written regarding Mr. Krakowski's early life and family history. Your Honor, it's fairly common in situations like these for me to learn things about my clients that I had never thought to ask, that they had never revealed to me, that they never disclosed to me. And without getting into all of the details, I would say the account here from Mr. Krakowski is clearly traumatic. It seems here that he was a caregiver for both of his parents from a very, very young age. I see here that he took on the responsibility of assisting with bathing, cooking, cleaning, doing laundry, all from around the age of, it seems, 11 or so. And from what it seems to indicate, perhaps even earlier than that. Your Honor, I don't think that any child should have that weight put on their shoulders. I think that it's unacceptable, inappropriate, for one. But more than that, I think that it creates the trauma that led Mr. Krakowski on his path to where he is today. I think putting all of that responsibility on the shoulders of someone so young, responsibility that should belong to the people who take care of them, inevitably creates the circumstances that led him here. And I say that, Your Honor, not to put the blame on Mr. Krakowski's parents. I'm not blaming them. He doesn't blame them. He takes accountability for his actions. But I think looking here at the memorandum, the prior history, I begin to see a pattern. I see a pattern of falling into a difficult situation, panicking, acting out of impulse. And again, I don't offer that as an excuse, Your Honor, but simply to say that I think that Mr. Krakowski, at his core, I think he is a good person. I think he's a solid person. I think that given proper constraints, given guide rails, so to speak, I think he's capable of doing very, very well. I'd note that in the time that he's been in custody on this case, he's been heavily engaging in programming through the jail. He's been participating in Alcoholics Anonymous, Bible study, parenting courses as a means of preparing himself for reconnecting with his family, specifically his granddaughter. And what again struck me was his participation in the HSCD program. Mr. Krakowski already has his HSCD. He's had it for quite a while, in fact. It's my understanding that he was a tutor assisting, I believe here it was a Wade Brabant in the program. I filed a letter of support with the court. I believe the court received that. So I won't go into all the details on that, but suffice it to say, I think Mr. Krakowski knows that he can't sit idle. He doesn't want to sit idle. He wants to go out and be the best version of himself that he can possibly be. And part of what engaging in the jail programming for him means is building a foundation, taking the steps that are necessary to avoid ending up in this situation, to avoid falling back into the repeated patterns of behavior, to avoid having that panic, impulse, action response. In addition to this, Your Honor, Mr. Krakowski has been making ample plans once he is released and out of custody. It's his intention, to relocate to Superior, where he intends to complete a welding program course through Northwoods Tech, and is aiming to secure union employment and work on the Blatnick Bridge. As the state mentioned, Your Honor, Mr. Krakowski has been diligent and has worked and paid for prior restitution, for other fines and fees. He is a hard worker, Your Honor. He's someone, again, who does not want to sit idle. He wants to go out and do things and do good in his community, to earn a living, to pay off his debts to society. I can understand the state's perspective here in regards to concerns regarding release. However, Your Honor, candidly, Mr. Krakowski is an older man. He does not have that many years left to be out in the community, to be out working, to be making an income and to be making these payments. My concern would be that if this sentence were ordered consecutive to his current sentence, by the time he was released and back out of the community, he would not have enough time to secure savings for retirement, to avoid, in his own words, becoming a burden on society. I think the recommendation here from the defense is appropriate under the Galleon factors. Mr. Krakowski, as the state mentioned, will continue to be under supervision even after he gets out from his initial confinement. He's going to be on supervision for quite a long time. I think the community will be sufficiently protected. It has been protected already by the lengthy period of incarceration and will continue to be protected going forward. This involves an amount of upfront incarceration, Your Honor, that Mr. Krakowski is willing to face head on. He's accepting his punishment here today, and in engaging in the programming through the Wisconsin prison system, he will hopefully be able to address all of the issues, all of the trauma, all the bad things that have happened to him, and avoid coming before this court or any other court in Orange again. Overall, Your Honor, I think that a recommendation of 2 years initial confinement, 2 years extended supervision, and eligibility for ERP after 1 year running concurrent is an appropriate resolution to this matter. I would ask the court to follow it. Thank you.
Thank you. Mr. Krakowski, I'm now going to give you an opportunity to make any statement you wish. Let me know anything that you want me to know and you want me to consider before sentencing. You said you have something to read.
Yes, I do.
Please, when you read it, please go slowly and enunciate your words. And for the record, Mr. Feliski, I did read the sentencing memorandum and I did read the letter from Mr. Brabant or Wade Brabant about those things. Mr. Krakowski.
Thank you for this opportunity.
I'm going to actually have Mr. Feliski bring the microphone closer to Mr. Krakowski's mouth. Mr. Krakowski, please speak up. I need to hear you, but most importantly, my court reporter needs to hear you.
Thank you for this opportunity, ma'am. I was doing well. I held a good job at American Excelsior for 2.5 years. For the first 6 months, I was in a feeder position and then got a promotion into the maintenance technical position for 2 years. I had my own rental property or apartment for 2.5 years in Rice Lake, bought a car, bought a truck, bought a motorcycle, paid off most of my restitution that I owed, and stayed clean and sober and was a solid positive part of my 70-year-old granddaughter's life. After losing my employment because of a misunderstanding on my part of the attendance point system, they were forced to let me go per company policy. While unemployed, I relapsed and I started to get behind in my rent and was in fear of losing my home. Tempted in a time of crisis, I was weak and foolish. Temptation is no excuse for sin or breaking the law, and I regret that I fell back into my old criminal thinking when I should have sought help rather than lose faith in myself, my fellow man, and the Lord. I don't believe I have a lack of knowledge, yet I'm always seeking more. What I lack at times is the wisdom to trust in my knowledge and to provide what I need. I have done well in the past. I know I am capable of holding down a good job. I know I do not need to use drugs to live or to cope. I just need to reach out for help rather than let my shortcomings and my anxiety get the better of me. The more I reach into the scripture and God's word, the more confidence I feel I have to stand up to temptation, the more I know I'm not alone to face fears, loneliness, and trials and tribulations. In my past, I knew God, but over the last several months of isolation with thousands of hours alone in my cell with my regrets, I have come to know him and his promises to never leave me or forsake me. And by spending much of my time with him, my faith has grown. I no longer need to fear failure. I will keep going in spite of it with the Lord at my side. I cannot express in words how deeply I regret my actions. My random act of theft was not meant or directed in a personal manner, albeit that it may feel that way to the victim. And I personally apologize for violating their property, their privacy, and for taking what was not mine. I'm truly sorry. I also apologize to the court. I cannot take back the wrong that I've done. All I can do is say that I'm sorry and let you know that since being incarcerated, I have been doing everything in my power to better myself and my way of thinking. I've sought out and attended every class and group available that is offered here at Burnett County Jail in order to improve my thoughts, my way of thinking, so that I don't fall back into that criminal thought pattern, and will continue to seek the wisdom to make better choices in my future. Upon my release, I plan to continue a welding course. I'm currently enrolled in the Northwoods Tech. I plan on finding a TLP in Superior upon release and try to get secure employment on the new bridge going in Superior, and if given enough years, possibly retire after that project is completed. I've attended and participated in some 20+ hours of parenting class to become a better example and better role model for my 7-year-old granddaughter. Earning participation certificates for each class attended. I have participated in 2 or 3 weekly AA, NA groups, attended weekly Bible study and Sunday morning church services, and enrolled in Northwoods Tech HSED offered here at Burnett County Jail, and was asked to attend by the instructor Wade to be a tutor and help the other inmates study for their HSED, since I had already achieved mine. And I also have enrolled in the welding program at Northwoods Tech, and am currently working on the textbook portion of that course, and will be prepared to complete the course upon release. I'm doing this to further my education and add to my resume that already includes HSED, a custodial services technical college degree from Moraine Tech College in Sheboygan, plus an 1,800-hour apprenticeship program through the state of Wisconsin that qualifies me as a journeyman custodian. And I also have many, many years of work experience. I asked the court at this time to allow me as short an incarceration time as possible in order that I might get out and become a law-abiding, tax-paying citizen again, and not be a further burden on the state. Given my age of 58, soon to be 59, if returned to society, I will still have time to work and support myself rather than become a burden upon release. Thank you for this consideration.
Thank you, Mr. Krakowski. All right. Mr. Felisky, I'm going to turn to you. I know that you were moved in all of this by Mr. Or Ms. Felisky by Mr. Krakowski's information. I've heard this before. This isn't the first time I've read it or heard it. I'm aware of his upbringing. I'm aware of the trauma that he experienced as a child. I'm aware of the trauma that his life has put upon his son, because I sent his son is in prison right now. I'm aware of all of those things. I'm also very readily aware of the fact that many other people in their lives have had, if not the same, extremely similar circumstances, and they don't sit in orange and they don't go to prison. They do other things. They figure it out. It doesn't mean that your life didn't suck in the beginning. Did you deserve it? Absolutely not. Not one bit did a 10-year-old deserve having to live the life that you lived.
Doesn't make an excuse.
It is no excuse.
It is not.
And
I understand that.
the most horrible thing about it is the fact that not only did you then do this to your life, but my God, your poor son, because he saw you and you led him down that other path. And I've went through this again, and this is maybe a little bit more for Mr. Felisky to understand. Mr. Krakowski's ex-wife, the mother of their son, I believe it's Patrick, their son Patrick, continued to stand by Patrick's side and even Mr. Krakowski's side, because I truly believe I understand and I feel the heart. There's a good heart in there. You want to be a good man. The problem is that's why you weren't married, and that's why Patrick is in prison, and that's why Patrick does, or your granddaughter doesn't have a father. That's why it's hard for her to have a grandfather. But there were other children Patrick had other siblings that are not this way. They are totally the opposite of this way. And it's very extremely unfortunate. I am a person that I have empathy, and I feel the pain of that poor little child that you were. I feel the pain of your son and how he felt, because I've heard similar things from him as he was growing up and how he got his path from his dad and all of those things. I get that and I understand, but here I'm dealing with a 2008 Polk County case, extremely similar, except there you were armed, granted as a party to a crime, but it's almost a 20-year-old case. It's almost 20 years. And not only did we hear about that case, but then Mr. Schmidt went on about, and then this conviction went to prison for this, and then this conviction, and then did this, and then did this, and did this, then the other thing. You have redeeming qualities, Mr. Krakowski. You let the devil overtake you.
Yes,
You do. And you may have these spurts or little stints in your life where, hallelujah, you do take control and you do take charge and you do well. But then one little thing, click, knocks you off your path, and you just let that continue to roll down the hill, and it's rolling down the mountain. So that little pebble that got kicked down keeps building the snow and building it bigger and building it bigger and building it bigger until we have a 20-foot boulder of snow coming down and crashing upon not only your life, but everyone else's around you. You are 58 years old, Mr. Krakowski. You should be sitting on that rocker in the living room in front of the fire with your beautiful little granddaughter on your knee, reading to her, not having to tell her stories through a prison phone. And that's sad. And that it's taken 58 years for you to go, you know what, I'm done now. I'm finally done. But it hasn't, because this isn't the first time I've heard, I'm done. I'm finally done. I'm going to get on the right path. I'm going to do the right thing. Your crimes are bad. They make you a criminal. You are a criminal. You've done some bad crimes. It doesn't mean that you are a bad man or a bad person. You didn't try and kill somebody, but you could have accidentally. Burglaries are very violent, especially if somebody would have been there, and especially something could have happened, and God forbid, and thank God nothing did. We're looking at this case, Mr. Krakowski, this case where you should have understood, because you're still in extended supervision from a previous burglary and from other prison stints and those kinds of things. You were under surveillance. You will be watched until you're not. And you may never be off of paper, but you were being watched and surveilled, and people were on to you, and you risked it all for a bicycle, for a sweeper, for a vacuum, for a speaker, for a CD player, for a Sony CD player, another one, for another CD player, for another CD player, for a door, and for a few random parts from old vehicles. Absolutely nothing to risk your life for, or someone else's. Absolutely nothing to put in front of your ability to be a good man, a good father, and a good grandfather. A waste, a complete waste over junk.
I understand that.
Junk. Who uses a CD player anymore? And what could you get it if you even try to pawn it? $4? And Mr. Krakowski, and that's the sad thing. It really, that part is what breaks my heart as a human, because I truly do believe you want to do better. You want to be better. And I've heard it before. And I was here when your little grandbaby was first born. And now she's 7. It's serious because this is a burglary. It's serious because you have a criminal history of burglaries. It's serious because you have an extensive criminal history. I need to look at protecting the public, and obviously the lights blare and flash. Being on extended supervision, being and knowing that you're being observed and watched already, it's not enough. And I don't know when enough is going to be enough. I wish I believed that probation and extended supervision worked and it fixed and cured everybody, and everybody decided, hey, I'm not going to be a criminal. I wish prison was the answer. But even that's not. Prison is punishment. That's the sanctioned punishment part of the, hey, you're not getting it, you're not understanding, we're giving you every chance under the sun and you're not getting it. So now you have to go be with the big boys and not have fun. And we take away all of your liberty. Because I wish, Mr. Krakowski, you would have gotten it in 2008 or 9 or 10 or 11 or 12 or 22, 23, 24, 25. And you're here again. And it's my task to try and stop it from happening. It's my task to say, hey, enough's enough. What is it going to take? What is it going to take for Mr. Krakowski this time to get it? I am happy to hear that you are now reconnecting with God again in your spirituality. That is positive and that is good. I am happy to hear that you're reconnecting with your soul and wanting to be a good man and a good person. Those are great and those are wonderful. And I really, really believe you mean them. But here it's looking at all of those other factors and all of those other things, and when's enough's enough. You're 58. You should have, quite honestly, figured this out a whole lot longer ago than sitting here now. But it's not a situation where I lock you up and I throw away the key and I think, you know what, that's where your life's going to be now forever, amen. It's not that kind of thing, because maybe, just maybe, this time you'll do it. Because we don't even know if tomorrow exists, Mr. Krakowski.
You know what?
You might wake up and not wake up tomorrow. So in hearing all of the arguments and knowing all of the factors here that the court has in front of it, there needs to be a bit more punishment with the ability to be able to do what you say you want to do and to change your ways, to rehabilitate, to do those things. But with regards to this case with count 1, I'm sentencing you to 4 years of initial confinement with 4 years of extended supervision consecutive to any and all other sentences. I was quite tempted to say, based upon all of the facts and all of the history, that I would not make you eligible for the earned release programming. But hopefully this time, Mr. Krakowski, this time will be it and you'll get it. But I think there still needs to be more punishment. I don't know what's going to happen on the extended supervision. This is consecutive because different dates, different times, different places, different victims, different all of the things, different decades. So you must sit 2 years of this sentence before you would be eligible for any earned release programming. I am going to say that the 182 days of jail credit can count. Okay? Usually I say no, it has to be from the date you get to prison and you start my sentence, but you have 182 days of jail credit. So that'll apply. So it'll be 2 years minus 182. 2.5 or a year and a half or something. And again, it's because I want to give you that chance, but you also have to have that punishment. While in extended supervision, no contact with victims or residents or any vacation homes, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no cohorting, commingling, being around anyone who is on active extended supervision or probation for any burglary or any illegal substances unless approved by your agent. Because I know your son will come into play. So unless approved by your agent. Again, 182 days of jail credit, $518 in fines and fees, $2,930 in restitution. All of the court-ordered restitution, court costs, and fines are to be collected at a percentage determined by the Department of Corrections to be reasonable while you are in state prison as a condition of extended supervision as well. Department of Corrections shall collect all of those fines and fees. I'm ordering you to provide your DNA. This is not a case that you would be able to have it expunged from the system. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, you're always going to owe it, but the court will issue a warrant. You could sit up to 6 months in jail. The court will also give you the ability to have a financial review hearing once you're released to determine your ability to pay with regards to your restitution for a set payment amount and or court costs and fees. Especially if you're having a significant and substantial financial hardship. Mr. Schmidt, what am I missing?
With the ERP, is it the court's intent that he start at 2 years or that he becomes eligible for the benefit at 2 years?
He can start at 2 years.
Okay. That was
But
my only
again,
question.
I'm allowing that credit to the 182 to be applied to it, which I usually do not do. Well, and here's the thing I'll state on the record. I may reconsider as it relates to when the ERP is applicable if he can complete it prior to and be released after 2 full years or whatever serving the sentence. It's quite honestly all very dependent on what happens in the revocation. Because if he gets 2 years, 2 months and 2 days, then that means that there's 4 full years almost here that he's going to have to sit before he can even start ERP. So depending on what happens with DOC, and I'm stating it on the record because I have to, I may reconsider that part. Anything else, Mr. Schmidt?
No.
Mr. Flisky?
No, thank you.
All right, thank you. Then we are adjourned.